Main opposition party spokesman Mr. Metuh, in the company of his wife and relations, chatted away as they waited for the court proceedings to commence. As soon as the judge arrived, Mr. Metuh, who was to open his defense, told the court that he had filed an application. But the prosecutor, Mr. Sylvester Tahir, interjected by telling the court that the prosecution had an amended charge to replace the initial charge for which Mr. Metuh had entered a not guilty plea. According to the prosecutor, the amendment, which involved adding the word directly and formed to the 7th-count charge, was harmless. With no objection from the defense counsel, the charges were again read to Mr. Metuh, who entered a not guilty plea.
The amended charge, just an harmless and innocuous one. We merely dotted the I's and crossed the T's so that we conform with the necessary elements of the offense as stipulated under the law.
As far as we are concerned, whether it is the old one or the new one, we feel that they have not made out a case.
Done with that, it was time for the business of the day. Or rather than open a defense, Metuh, through his counsel, opted to make a no-case submission. He urged the court to allow him do so through a written address. The court agreed with Metuh that he was at liberty to decide how to handle his defense. While counsel to Metuh explained the reason for his client's decision, counsel to EFCC dismissed the move as a delayed tactics by the defense.
Well, we have reviewed the evidence led by the prosecution so far, and we are of the view that they have not established the ingredients of the offenses charged. And it is a defendant's prerogative to move the court to hold that there is no basis for the defendant to enter his defense.
Now, in the criminal trial process, for those of us in the prosecution business, we know that it is normally a stopgap. It's one of the bridges that normally we cross. Most defendants would not willingly like to open their defenses, no matter how tight the case is.
The case had been adjourned to today to allow Mr. Metuh to open his defense, but having chosen to go the no-case submission route, Mr. Metuh will try to convince the court that the EFCC has made out no case whatsoever against him. As such, the charges should be quashed. Amaka Okafor, Channels Television News.